Welcome to the live virtual classes of Board of Studies ICAI, and we are dealing with CA intermediate course. The topic which we are discussing now is interpretation of statutes, and this is the second session of this topic under the paper 2, corporate and other laws. In the previous session, we have discussed about interpretation of statutes in quite detail, and we tried to understand the initial meaning of interpretation of statutes and some rules around interpretation of statutes. Today, we will be continuing that discussion and we'll take the discussion forward. So in the previous session, you gained knowledge about the need for interpretation of statutes, and also you were now in a position to explain the various rules of interpretation of statutes. Particularly, we classified the 4 important rules which are there, which again we will reiterate today to understand how these rules are important. And we will also see how you would be able to, explain the various internal and external aids to interpretation, that is help to interpretation. And then also to comprehend the rules of interpretation of deeds and documents. So though the statutory rule of interpretation exactly does not apply to interpretation of deeds and documents, but some basic principles apply as it applies to statutes, it applies to interpretation of deeds and documents. Like, for example, it is said that deeds and documents has to be read as a whole again. But if one part of the deed is making sense, then you should interpret in that particular way, severing the other part of it. So I'll come to that, towards the end of the session, where we will discuss about that. In terms of the chapter overview, we have discussed about primary and secondary rules. Now, today we are focusing more on aids to interpretation, that is internal aids and external aids. If you remember, last time we talked about some basic principles, and these are the 4 basic principles. But I would like to, the students to, recollect these principles, and if they can type it in the chat box or want to speak, you can speak as well. So let us see what are the principles. Quite basic principles, 4 basic principles which governs the interpretation of statutes. How do you deal with that? Yeah. Can you name them? Which are the principles? 4 principles. These are basic of interpretation of statutes. What is the first principle? If you find these 4 principles, they are not, in sequence written in your course material, but all these 4 principles are part of your study material, and there are questions which has come on these areas. So these are basic to interpretation. And if you see, these principles we discussed in a sliding scale approach. So we begin with the first principle, and then towards the end, we go ahead with the last principle in this. Yeah. Yes, any input? I think we are having a couple of students. Yes. Looking forward to your input. Okay. Seems you people are grappling with that. Okay, fine. So there are 4 basic principles as we have discussed in our previous class. The first principle basically focuses and talks about intention of the legislature. So whenever you are going to do an interpretation of a text or a statute, you look at the intention of the legislature. And where do you get the intention of the legislature? Intention of the legislature has to be read by the words which are used in the statute. So the law which refers to the different words and sentences, you get the intention of the legislature from that. Probably there are some internal aids and external aids to interpretation. You look towards that as well to find the intention of the legislature, which I will teach you just now. Apart from intention of the legislature, the second important criteria which is there for interpretation of a statute is that statute must be read as a whole in context. So you have to see the context. I have used it before, and again I am repeating that context is the king. So you have to see the law in the context, in the factual scenario, and accordingly interpret it. So here statute must be read as a whole in its context, and it cannot be dissociated from its context, right? Third important principle is that if the meaning is plain, if there is a meaning is plain, effect has to be given to that particular meaning, and you will not try to make some other meaning out of it. And this is irrespective of the consequences. Even if the consequences are a bit, harsh, you go ahead with that particular interpretation. You would have recollected, I can give you an example, that when building norms or bylaws are not followed, the whole building, 16 stories, 18 stories, 20 stories buildings have been raised on the orders of the Supreme Court. They have not looked at the consequences, that how much loss would be. But if there is an illegality and the law says that such a structure cannot be there, then they have, broken that particular structure. So this is a basic application of this rule, that if meaning is plain, effect must be given to it irrespective of the consequences. And the fourth one is statute to be construed to make it effective and workable. So statute has to be construed in a way that it becomes effective and workable. So you cannot just brush aside a law saying that it is not workable, or we are not able to make sense out of that particular law. So you have to find out the maximum sense which can come from that particular legislation. Though in courts have interpreted laws like that before, and has also recommended a reform in that particular law. And we have seen a number of reforms in number of legislations have been done pursuant to those recommendations. I can give you several examples, like, for example, IPC, we have changed in BNS. Similarly, if you will see insolvency bankruptcy code, many changes have occurred over the years on the basis of the recommendations of the judges in different cases. Similarly, if you look at Competition Act, Companies Act, all these legislations, particularly economic legislations, have undergone several changes. And the courts have, while interpreting the provisions, provided an effective and workable model for these statutes, right? So these are the four principles which are an important principle whenever you are working for interpretation. So whenever you want to interpret something, you follow these principles very, very clearly. Now, if we move further and talk about the rules of construction, there are primary and secondary rules. And if you recollect, in our previous class, we already had covered the primary rules up to, I think, rule of exceptional construction. This is what we did. And today we are going to cover rule of ejusdem generis, doctrine of nocere socii, and doctrine of contemporanea exposito. So my question to you would be that if you are able to explain in one line rule of literal construction, rule of reasonable construction, rule of harmonious construction, and mischief rule and beneficial construction and exceptional construction, if you can give some example or maybe one-liner explanation, it will be great. Because I have already taught you this particular topic and I shared the slides also with you. So in case you can type it, I will be happy. If you want to speak, we can enable the mic as well, and you can speak about this to begin with, rule of literal construction. Go ahead. Yes, rule of literal construction. What does it say? If you have to say, for example, write 2 lines about it, what do you write, or what do you say? Okay, Daksh, thank you for that input. Rule of literal construction is the language of the statute should be read as it is. Okay, good. Law must be read as it is, Isha. Yes, plain meaning rule come. I will use your name, Narsimha. Yeah, you're right. So basically, literal construction says that whatever is written you go ahead and interpret that. You don't supply anything, you don't make any construction out of it. It is a plain and simple meaning. That is rule of literal construction, and this is the basic rule of interpretation. You start with literal construction. If literal construction is giving result, you don't go to any other rule. You follow that literal construction. But many a times, the statute will be not that clear, and you have to go ahead with two or three different constructions. That is rule of reasonable construction. Uh, Anil, I think reasonable is simply with some goodness to parties involved, not exactly. So if you are talking about beneficial construction. So whenever we are discussing about goodness to the parties, we are referring to the beneficial construction, right? For example, labor laws or maybe laws specifically related to women or children. These are all beneficial construction rules, right? Or laws relating to minorities. These are all beneficial construction. So these are liberally interpreted if there is a rule of beneficial construction. Yes. Daksh says rule of reasonable construction, the statute should be construed so as to lead to a sensible meaning. Yes. And it means that intention of the maker and general sensibility should be seen as above its meaning. Very true. So rule of reasonable construction is basically that you should draw reasons from the text. So it should not be, vague. It should not be giving you results which are absurd. So when you are interpreting, you should avoid absurdity. Very well said, Aisha. So when certain absurdity happens, avoid absurdity, reasonable construction is applied. Very good. What is harmonious construction? Harmonious construction. Yes. Harmonious construction. Anil, it is not basing on previous laws. Harmonious construction refers to, basically, I can give you a hint. It is referring to two legislations or two provisions of one legislation. It is not about Narsimhan, it is not about parties. So it is not about parties and giving harmony to them. Yeah. Yes, Isha, you are right in a way that to avoid conflict between statute and object of the legislature, it is basically whenever you go ahead with the harmonious construction, you are either referring to two conflicting provisions of two different statutes or the same statutes. So whenever there is such a situation, you try to give a harmonious construction. Like for example, in constitution, most of the times there is a conflict or there is a perceived conflict which comes in interpretation of fundamental rights and directive principles of a state policy. So directive principles of a state policy is not enforceable, whereas fundamental rights are enforceable under the Constitution of India. So in many cases, particularly Minerva Mills case, the court has held that you have to come up with a harmonious construction. So if there is a conflict between interpretation of two provisions, you try to find a harmony between these two and give an interpretation which helps you apply both these sections or the situation handle that particular situation. So this is basically Narsima, you are right. Avoiding collision in classing of sections. This is a good way to explain this. Okay. So this is about harmonious construction. Anybody on this Hayden's case rule or mischief rule? What do you understand by mischief rule? Mischief rule. Yes. Mischief rule. Any idea? Okay, okay, that is fine.
Is gaining popularity across the state and beyond the state.
Yeah. Anyone else? Isha, to suppress the mischief and advance the remedy to suppress the evasion of continuous mischief. Okay, fine, but can you give some more explanation on this rule of Hayden's or mischief rule? Yeah. Okay, let me explain mischief rule again. Mischief rule is a rule where you are looking at the law from a perspective that what mischief it is trying to cure. Like say, for example, if the law provides for higher penalty for red light jumping. Now, point is here that why the higher penalty is provided, because there are a lot of people who are jumping the law, jumping the red light because there is a lesser penalty. So mischief here is that the people are jumping red light. Now, the cure of this, they are trying to see that whether higher penalty can reduce that jumping of red light or not. So this is the mischief which is it is trying to cure. So whenever a legislation a court will be referring to with reference to its penalty or higher penalty, it will look at it and point out that it is a mischief. It is by way of a mischief rule. So rule in Hayden's case or mischief rule, right? So this is a rule which is there. Rule of beneficial construction we have already discussed. Rule of exceptional construction is basically a situation where the court departs from the literal construction. Then it is called exceptional construction. So if you will see in many situations, the court has to go beyond the ordinary or grammatical meaning. Like, for example, when shall is interpreted as may, this is a exceptional construction because otherwise shall should be read as shall and may should be read as may. But in certain situations, you will find that the courts reads shall as may. We have seen that, and again we will see it in one of the slides. So this is this is called rule of exceptional construction. So I hope these rules are now sufficiently revised and you are clear about these rules. That is rule of literal construction, rule of reasonable construction, rule of harmonious construction, and mischief rule, as well as rule of beneficial construction and rule of exceptional construction. Now let me take you further and talk about the remaining three rules. That is rule of ejusdem generis in primary rules and secondary rules, doctrine of nocere socii and doctrine of contemporaria expositio. So, but before we move to these particular rules, there are few points which I wanted to make. There are, in interpretation, there are some conjunctive and disjunctive words. So conjunctive words, as the name suggests, it is there to join two parts of the sentences or words. Disjunctive is meant for dissociating or removing them. Can you give an example of conjunctive and disjunctive words? Yes. Can you provide? And, or, but. Very good. So, Isha, you're right. So this is, we are discussing about and or. So in most of the places you will find in and or, these are conjunctive and disjunctive words. So wherever there will be and, that means you are including those words into single. And when it is or, it is an alternative, right? So the word or is normally disjunctive and is normally conjunctive. But at times they are read as vice versa to give effect to the manifest intention of the legislature as disclosed from the context. This is what court has said. Now there are situations where you have to read and as or, and this was the case of Professor Yaspal versus State of Chhattisgarh. In this case, there was an expression established or incorporated, which was used in section 2F, 22 and 23 of the University Grants Commission Act. So UGC Act basically, provides for establishment of the university, and there it has used the word established or incorporated. Now here the court read this as established and incorporated because the university has to be established and incorporated. It cannot be or incorporated. It has to be established as well as it has to be incorporated, having regard to the constitutional scheme and in order to ensure that act is able to achieve its objective. So this is how it is interpreted, and conjunctive and disjunctive words are sometimes alternatively used, just like may and shall. Now, if you will see in another case, that is Ishwar Singh Bindra versus state of UP, 1969, the court was referring to the word substances definition in section 3B of the, I think, Magical Remedies Act, that is the law, where 3B means something other than medicines. The word and used in the definition of drug between medicines and substances is to be read disjunctively. Disjunctively means it is trying to read and as or. So it is, this case is also referring to Stroud's Judicial Dictionary, and it says that generally a cumulative sentence requiring the fulfillment of all the conditions that it joins together, and herein it is antithesis of or. Sometimes, however, even in such a connection, it is by force of contents read as or. Similarly, in Maxwell also they have talked about this disjunctive and conjunctive words. So try to understand that in normal circumstances, or will be read as disjunctive and will be read as conjunctive, but there may be situations where to actually give approval to the intention of the legislature or give credence to the intention of legislature, you read and as or as and. I can give you another example, and this example is with reference to Iridium versus Motorola, that is a corporate criminal liability case. So it was Virappa Textiles case, in which Justice B.N. Sri Krishna was one of the members, and the court was of a view that wherever in a statute the penalty is mentioned for a company as and, so it says that punishment for a fine of so and so rupees and a punishment for jail of 2 years. Now, here the court interpreted this in a way that corporations, the company, which is a separate legal entity, cannot be sent in jail. Hence, these provisions will not apply to the companies. So this was the position in Veliappa Textiles. However, later in Standard Chartered case, the court basically looked at this and they said that this will be a fallacy of interpretation. This is not exactly what intention the legislature had. Legislature may not have an intention that individuals should be put behind bars, but companies, just because 5 individuals have formed a company, they should be scot-free. So they considered this and as or, and prosecuted the companies for fine, and definitely they cannot be sent for jail, but at least a fine was imposed on the companies, and this is the case of a Standard Charter. Later on, in Iridium versus Motorola's case, the court specifically emphasized and talked about mens rea of the companies, and like that, the criminal, corporate criminal liability concept was established into the Indian jurisprudence. So I hope you understood the conjunctive and disjunctive word differentiation. There is also mandatory and directory provisions. This I am repeating again because we have discussed this, if you recollect, in the General Clauses Act, that may, must, and shall. So if you will see in one of the cases, Punjab National Bank versus Ghulam Dastagir, the statute stated the landlord may apply to the court for eviction of the tenant in certain circumstances. Now here the Supreme Court said that may imposed a duty, not a discretion, on the landlord to apply eviction under the specific circumstances. The landlord said कि घर से निकल जाओ. There is no need for you. You get out from my house. And when it was referred that no, fine, for eviction you need to give him the notice as per the law, he said he's saying may apply to the court for eviction. I am not supposed to. It is not saying shall, so I should not apply for eviction in the court of law. So this is what was the interpretation. And the matter went till Supreme Court. You can see Punjab National Bank versus Ghulam Dastagir, and court has to come and say that the word may was interpreted as shall, as leaving it discretionary would defeat the statute's purpose for protecting the landlord's rights. I hope you have got the context. In another case, state of UP versus Man Bodhan Lal Srivastav, the Article 323C of Constitution of India stated that it shall be duty of the Union and State Public Service Commission to advise on disciplinary matters. Now, the question here was whether consulting the PSC, that is Public Service Commission, was mandatory or merely directory. The court held that despite the use of shall, the provision was directory, not mandatory. This interpretation ensured administrative decisions were not invalidated solely due to non-compliance with the advisory requirement. So this is how the provisions have been interpreted in these two cases. Let us move further and talk about another case, that is Lakshmi Narayan versus Union of India. Here, the word must in place of shall will itself be sufficient to hold the provisions to be mandatory. So in a case, there was previously used the term was must, and later on they converted it to shall. So the court interpreted this change as making it mandatory. So the use of word shall with respect to one matter and use of word may with respect to another matter in the same section of the statute will normally lead to a conclusion that the word shall imposes an obligation, whereas the word may confers a discretionary power. But that by itself is not decisive, and the court may, having regard to the context and consequences, come to a conclusion that part of the statute using shall is also directory. So my bottom line is that whenever these such questions comes up, the court looks at the facts of the circumstances of the case and applies the law accordingly. So this is how the interpretation of may and shall is carried out. I think this slide I have already discussed before, so I will not go into this in much detail. This is just for your reference. I will leave it here. If you look at your course material, these two examples have been used from Companies Act, Section 3 and Section 21, wherein may and shall has been interchangeably used. In another case, Vidarbha Industries Power Limited versus Axis Bank Limited, this case also we discussed in our previous class. It talks about use of may in Section 7(5)(a), which deals with financial creditor, and use of word shall with reference to operational creditor. So it is saying that in one situation, the legislature has used the word may, and in another situation, it has used the word shall. So hence, the use of word may and shall in identical provisions show that may and shall in two provisions are intended to convey different meaning. It is apparent that legislature intended 9(5)(a) to be mandatory, whereas 7(5)(a) of the IBC to be discretionary. So if you will see in 9(5) operational creditor, there is a requirement of a notice before they can go ahead with the filing the petition, because they have to satisfy the first initial remedy of asking for the money, and then if it gets unpaid, then only they can come up under the CIRP process. However, in case of financial creditor, there has to be only a default, and by default they can file the case. So this distinguishes these two different sections by way of may and shall, and this is what the court interpreted in this particular matter. Now we are moving to the secondary rules, and one of the rules deals with rule of ejusdem generis. But before I move on to this rule, I would like to ask you any question if you have, or any other idea. So Achal asked the question, scot-free means. Scot-free means to run away, or is left, or is freed. This is what is the scot-free. Yeah. Any other question you have? Any one of you? Any other question? In case you people don't have any question, you can write no, so that I know that yes, I need to proceed. Okay, fine. So let us move further and talk about the secondary rule, that is called ejusdem generis. So this ejusdem generis rule is a rule which says that where specific words pertaining to a class or category or genus are followed by general words, the general words shall be construed as limited to the things of the same kind as those specified above, right? I can give you an example. So say, for example, if the law lists automobiles like trucks, tractors, and motorcycles, and a general term vehicles is also there as the fifth point, then you have to refer to vehicles as not airplanes or boats. You have to refer to them as the vehicles which can run on land or land transportation. So this is something which is by way of rule of ejusdem generis. You don't have to be having a specific rule. By rule of ejusdem generis, you will make the interpretation like that. Similarly, in case of animals, if the law lists dogs, cats, and other animals, the general term other animals would be interpreted to mean similar to dogs, cats, and they would not include birds and fish, right? So they are talking about mammals and they are talking about probably domesticated mammals. They are not talking about amphibians. They are not talking about birds. So here, this is how the distinction you have to draw. So whenever some specific terms are used in a statute and there is a generic term, you refer the generic term in line with the color, in line with the text which is there for the main term, right? So this rule applies when the statute contains an enumeration of specific words. The subject of enumeration constitutes a class or category, and that class or category is not exhausted by enumeration, and general terms follow the enumeration, and there is no indication of a different legislative intent. This last point is very important. So the law may specifically mention also its intention, and it may differ from rule of ejusdem generis. So if there is an express written word which says that nothing said in this particular section can be invalidated or is subject to interpretation of something. If that is the situation, then rule of ejusdem generis will be a relaxed rule, because then you cannot, stick to the requirement of following the previous word meanings when a generic term is there. So this is about rule of ejusdem generis. I hope this is clear to you. Now let me take you to another important interpretation, secondary rules of interpretation. That is doctrine of nocitur e socii. Okay. So please carefully note this, not doctrine of nocitur e socii. It is quite an interesting, maxim, and it says the meaning of a word is to be judged by the company it keeps. So it says that the company you keep, you will be known by that, right? So Lord Macmillan had said this in one of the cases, and the idea is that associated words take their meaning from one another under the doctrine of nocitur e socii. So in Hindi we call it, no, जैसी संगति रहेगी वैसा ही कलर आपका दिखेगा. So this is what it is trying to say, that the the words which are in a particular company has to be given that color. Generally, this happens in case of customs matters, in case of taxation issues, where you are looking at the category of produce into a particular category, because people will always try to come to a lower bracket, right, by way of one or the other point. But taxation authorities would try to bring it in the higher bracket. So this thing, mostly you will find it in taxation related issues, in customs related issues. So in one of the examples, that is Commissioner versus Savoy Hotel, the question was whether the fresh orange juice is a fruit juice or not, right? So while dealing with the Purchase Tax Act, which used the expression manufactured beverages, including fruit juices and bottled waters and syrups, it was held that the description fruit juices as occurring therein should be construed in the context of the preceding words, and that orange juice unsweetened and freshly prepared or pressed was not within the description. So they said that they are talking about processed food. They are not talking about fresh juices which is coming from oranges directly. So This is how the interpretation they have given through the applying the doctrine of nocere socii in the case of Commissioner versus Savoy Hotel. Another case which came up in Supreme Court was Pradeep Agarbatti versus State of Punjab. So the term here was perfumery. So in entry 16, they use the term cosmetics, toilet goods, and perfumery. Now, they said that the word perfumery has to be looked at from the perspective of the context in which it has been used. It has been used in the context of cosmetics and toilet goods. Agarbatti has nothing to do with cosmetics and toilet goods. They are a separate category. So perfumery has no application to dhoop and agarbatti. This is what was held in Pradeep Agarbatti versus State of Punjab. Now you note that how small cases comes up. Another example would be Dr. Devendra M. Surti versus State of Gujarat. So in this case, the court was dealing with the definition of commercial establishment under the Bombay Shops and Establishment Act, which said commercial establishment means an establishment which carries on any business, trade, or profession. Now, here the word profession was construed with the associated words business and trade, and it was held that private dispensary of a doctor was not within the definition in this particular case, and that is Dr. Devendra M. Surti versus State of Gujarat, right? So these are the cases which have been dealt with in the rules of interpretation, secondary rules of interpretation, which deals with doctrine of nocere socii. Any question till this point? Because now we have done with the rules, primary rules and secondary rules. Now we will move ahead with aids to interpretation. Yes, Anchal, what you want to understand again? Can you just tell me? Daksh, agisdum generis basically means that you have to follow the generic word meaning from the specific word which is above. So that is what is agisdum generis. Yes, any other question? Yeah. If you see the slide which I was teaching you, it clearly says the specific words pertaining to a class or category of genus are followed by general words. This is called. Or if you have to explain it in simple words, you will say of the same kind or class, right? So this is what is agisdum generis, of the same kind or class. Then we have nocere socii. Yes. Any question? Let me see. Yes, interpretation is basically no sections. It is about interpretation, about how to interpret. Right. Okay. Now let me take you to another important maxim, that is doctrine of contemporanea expositio. Now this is also a interpretation tool for secondary rules, you can say. So it says basically this particular doctrine is based on the concept that statute or a document is to be interpreted by referring to the exposition it has received from contemporary authority. So the maxim contemporanea expositio et est optima et fortissima in lege means contemporaneous exposition is the best and strongest in the law. So this basically means that whenever you are interpreting a law, you go back to the context when it was understood in that particular way. So you have to go back to the time when it was passed. So if a law is passed on a particular day or a particular time, you have to go back to that particular period to understand what was the objective of that law. You may be surprised, the IPC was there since so many years, and we have been interpreting these provisions. So you go back to that when IPC was enacted and try to see why this provision exists and then apply it in the present context. So this is how the doctrine of contemporanea expositio comes forward. However, this maxim has been applied only to the ancient statutes, not to the uh, you know modern statutes, because that is how, if you have to apply of old law, you have to go back to the old period before you are applying them, because if you apply the old law in the modern context, you will not be finding the right results. So this is what is this doctrine about. Now, this is an example. Suppose a law enacted in 1700 has been interpreted by courts and government authorities in a particular way for over a century. And even if another interpretation appears possible, court may prefer the traditional interpretation for simply three reasons. One, people have arranged their affairs based on it. If you recollect, one of the maxims we discussed in the initial classes was ignorance of law is no excuse, right? So you need to have stability in the interpretation of law. So if people have arranged their affairs as per the interpretation, though it was a wrong interpretation or maybe original interpretation, you cannot change it midway that, okay, fine, now we have changed it. Second, it promotes legal certainty. So if there is a clarity, then it provides legal certainty. And then it continuous acceptance suggests that interpretation accords the legislative intent. So many a times in law, continuous application or a continuous acceptance of a particular fact becomes truth. And that is how it is been dealt with in this particular slide. Am I clear till this point? Any question? Let me see if you have any question. No questions so far. Any questions you can ask? I'm just waiting for you. Okay, clear? Fine. So now let us move ahead and talk about some other rules. So there is a rule of last antecedent. It is interesting rule. So it says basically that you need to look at the last word to find out the context. Like, for example, or it is also referred to as deeming provisions. So there are two kinds of word. One is affirmative and negative words. So affirmative words are, positive things, and negative words are words which, start with no. Like, for example, the statute in question, in case of Ramchandra Keshav Adke, the statute in question imposed a specific restriction on alienation of land without prior permission. So alienation of land is means, giving the land to someone on lease, gift, or in any other manner without permission. So the provision used negative words like no transfer shall be valid unless approved by the collector. Or the court held that use of negative language indicated a mandatory requirement. So if in a statute you find that the section is starting with a notwithstanding or with no clauses, then these are negative language and they indicate a mandatory requirement. You recollect the four classes of notwithstanding we discussed in our previous class? So you have to see it from that context. Then there is an affirmative language. So it says the applicant shall submit all documents by stated deadline. So herein there is a affirmative action required, the positive action required, that you have to submit all the documents and shall submit. While shall indicates an obligation, it could be treated as directory depending on the legislative intent. This we have already discussed. Now, if there is a text which says the install flooring, curtains or furniture made of wood. Now here you have to see the made of wood is a last antecedent and it will not apply to curtains and flooring, by the way. Okay. So somebody may say that tenant may install floorings, curtains or furniture made of wood. Now this was the term of the agreement in the tenant landlord agreement. And the tenant, installed wooden flooring. Will it be right if the tenant installs wooden flooring in this particular example? Or maybe he installs wooden curtains No. Why? Because you have to see made of wood with reference to furniture. Okay. So it is not with reference to curtains or flooring. So this is how it is called rule of last antecedent. Now let me move further and talk about internal aids to interpretation. So there are two kinds of aids. One is called internal aid to interpretation, and the other one is called external aid to interpretation. So internal aids basically refers to those aids or those help which you can find in the statute itself. So this is the Bare Act of Companies Act. For interpreting Companies Act, if you get all help from this Bare Act, that is internal aid to interpretation. We will talk about it one by one. But if you have to go beyond this statute, if you have to go away from the statute and look for different other things, like for example, legislative history, law commission reports, or maybe judicial precedents, international convention and practices, dictionaries, these are all external aids. So when there is an ambiguity in the statute and the statute internal aids are not able to help you, then you move ahead with the external aids, which are basically, additional texts which can help you interpret the provision. So this is the difference between internal aid and external aid to interpretation. Any question on this part? Internal aid and external aid, any one of you? Internal aid and external aid. Any question? Okay. No question? Fine. If there are no questions, let us proceed further. And I will be talking about the internal aid first. So internal aid to interpretation, as I said, comes from the statute or the book itself. So as you can see in this picture, the legislation or the book, from there you bring the aids, that is called internal aids. The internal aids can be listed as starting from, long title, preamble, heading, marginal notes, definitional sections, illustrations, proviso, explanation, schedules. These are all internal aid to construction. We will see them, each of them one by one. So first, let us begin with understanding the aids of interpretation. A brief note on that. So aid to interpretation basically is assistance, support, or help in interpreting. This is referred to as aids to interpretation. And aid is a device that helps or assists. Okay. For the purpose of construction or interpretation, and the court has to take recourse to various internal and external aids. Internal aids means those material which are available in the statute itself, though they may not be part of the enactment. Second, these internal aids includes long title, preamble, we have already told you. Even internal aids are not adequate, court will go to the external aids. External aids, again, as I listed before, parliamentary material, historical background, report of a committee, commission, or official statement, dictionary meaning, etc. These are all part of the external aid. Now, O. Chinnappa Reddy in Prabhakar Rao case said specifically, where internal aids are not forthcoming, we can always have recourse to external aids to discover the object of the legislation. External aids are not ruled out. This is now well settled principle of modern statutory construction. So in case of interpretation, we can go ahead with both the internal aids and external aids. The only caveat is that internal aids has to be first looked at, then one can move to the external aids. Now, let us talk about another important concept that is called pari materia. So, have you heard about this term before, pari materia? Any one of you? Pari materia. Okay. So, pari materia is a term which is utilized by the courts to refer to similar kind of a statute. Okay. So, this is called pari materia. So here in the case of district mining officer, the Supreme Court has said it is also a cardinal principle of construction that external aids are brought in by widening the concept of context, as including not only other enacting provisions of the same statute, but its preamble, the existing state of law, and other statutes in pari materia and the mischief which the statute was intended to remedy. So if you look at the doctrine of pari materia, the legal principle pari materia, that means on the same subject matter, is used when interpreting statutes or laws that are related to each other in terms of subject, purpose, or objective. The rule suggests that the law dealing with similar subjects should be interpreted harmoniously to achieve consistency. So what is the idea? Idea is that take help of a legislation or an interpretation on the same subject matter, right? For example, IPC defines offenses, right? So while the CRPC, now this IPC is BNS, that is Bharatiya Nyaya Sanhita, and while the CRPC lays down procedural rules for handling offenses, since both statutes deal with criminal law, they are considered as the laws which are pari materia. So you can refer to them in a same thing, but you cannot refer to CPC, that is Code of Civil Procedure, along with IPC. CPC is not pari materia to IPC. Similarly, if you are looking at IBC, Insolvency Bankruptcy Code, then probably Companies Act may be pari materia to Insolvency Bankruptcy Code because they deal with the similar kind of a situation of winding up. So in case of KP Varghese, Supreme Court again stated that interpretation of a statute being an exercise in the ascertainment of meaning, everything which is logically relevant should be admissible for interpretation. Now let us look at the different internal aids to construction. So the first internal aid to construction is long title. So the court, it is now long settled. It is now settled that long title of an act is a part of the act and is admissible as an aid to its construction. Like R versus Secretary of State, this is the case in which it has been said. So what is a long title? You can see here in this example on the right side, the Companies Act 2013. So you see here, it says an act to consolidate and amend the law relating to the companies. So this is the long title. And what is the short title? You can see here on the red, the Companies Act 2013 is the short title. So the title of a statute is an important part of the act and may be referred to for the purpose of ascertaining its general scope and of throwing light on its construction. And although it cannot override the clear meaning of the enactment, this is what was held in Ashwini Kumar Ghosh versus Arvind Bose in 1952 by the Supreme Court. So if you look at another example, the Bharatiya Saksha Adhiniyam, this is Indian Evidence Act. It says an act to consolidate and provide for general rules and principles of evidence for fair trial. This is what is the long title. So it tells you the, scope basically of the legislation, why the legislation is there, right? So this is the long title. So if you will see in another example would be the Aparajita Women and Child West Bengal Criminal Law Amendment Bill 2020-24. This came up after the RG Car case to amend the BNS, the BNSS and Protection of Children from Sexual Offences Act in their application to the state of West Bengal to enhance the punishment and to constitute a framework for inter alia expeditious investigation and trial of the heinous act of violence against women and children. So such a long title. Okay. So it is actually, in fact, coming to be a preamble rather than long title. So long titles are short sentence and it tells you the scope of the law. Okay. Now we will move ahead and talk about another case, this Ashwini Kumar Bose case. Okay. What has happened in this? So the case arose concerning the interpretation of a statutory provision relating to the legal profession under the Advocates Act. So a dispute arose basically between two categories of legal practitioners. One who is an advocate who practiced in the high courts and were enrolled under the Act. And the second were attorneys who were traditionally associated with Supreme Court of Calcutta. So in older days, everybody was not an advocate, by the way. Okay. In 1961, only the Advocates Act came up. And so there were a number of practicing attorneys at that point in time. So the question came before the Supreme Court that in terms of Advocates Act, who should be permitted to appear in all courts, including Calcutta High Court? So the court was having a question whether the long title of the Advocates Act can be used as an aid of statutory interpretation. So the long title of the Advocates Act went like this. It said, an act to authorize advocates of the Supreme Court to practice as of right in any high court. Okay. So the court looked at this, interpreted it, and reasoned that long title underscored the intention to harmonize and systematize the rights of legal practitioner, aiming to eliminate unnecessary distinctions between different class of practitioners. So the court interpreted it and held that attorneys have also a right to appear in the Supreme Court to practice, or a High Court to practice. So this is how the interpretation was held in this particular case. I hope you understood the application of long title in interpretation. Let me see if there are any questions from your side. Daksh, this is a side question which you have asked about Aparajita bill. There are severe punishment. In fact, there is a death penalty also for rape accused in that particular case, but it was not approved by the President of India because it was completely diverging at that point in time. Now let us move further and talk about preamble. So you all know about preamble, right? So preamble of a statute is like long title, is a part of the act. It is also an admissible aid to construction. So although not the enacting part, preamble is expected to express the scope, object, and purpose of the act. In fact, in Constitution, we call it as a torchlight. So the preamble of the act discloses the primary intention of the legislature, but can only be brought in as an aid to construction if the language of the statute is not clear. However, it cannot override the provisions of the enactment. It has to harmoniously read the provisions of the enactment. For example, use of the word may in Section 5 of the Hindu Marriage Act, 1955, provides that a marriage may be solemnized between two Hindus. Now, this has been constituted to be as mandatory in same sense that both the parties to the marriage must be Hindus as defined in Section 2 of the Act. Now, here in this case, it was held that a marriage between a Christian male and a Hindu female solemnized under Hindu Marriage Act was not permitted. It was void because it has to go ahead with the Special Marriage Act. So this result was reached also having regard to the preamble of the Act, which read an act to amend and codify the law relating to the marriage among Hindus. It was not talking about marriage between Hindu and Christian or Hindu and Muslim, right? So they refer to the preamble to look at the applicability of the law. This is the case Galipoli Sauraja versus Bandaru Pavani in 2009. So you saw this, how this is applied, preamble in interpretation, internal aid to construction, right? In another case, that is Karnataka Contract Carriages Acquisition Act. This was a case with Regional Transport versus DP Sharma. So here, the law provided for acquisition of contract carriages and for matters incidental and ancillary subservient thereto. So this had a very long preamble. You can see here, whereas the contract carriages and certain other categories of public service vehicles are being operated in the state in a manner highly detrimental and prejudicial to public interest, and whereas with a view to prevent such misuse and also to provide better facilities, etc., etc. So you can see this complete problem statement is written here, right? So whole mischief has been written in the preamble, that it is causing problem of so and so, and subserve the common good and to remove the this. So here the court interpreted it and used this particular preamble, and it said it is apparent from the preamble of the Act that the primary object of the Act is acquisition of the contract carriages with a view to preventing misuse and also providing better facilities for transport of passengers by the road. So you can see what has happened in this case is that contract carriages, that is private bus operators, government has took over. And this was challenged probably in a case, and they have looked at this Karnataka Contract Carriages Act 1976, and they said that this is a right thing because it is done in public interest after looking at the preamble. So I hope this is happened. So what is meant by solemnized? Okay, Wankhede solemnized basically means that marriage is complete, right? So this is called solemnization of marriage. So marriage gets solemnized, in family law, after the husband and wife accept each other. That is what is called solemnization of marriage, right? Are there any other questions? Any one of you? Any other questions on this till this point on preamble? Okay, so if there are no questions, contract carriages. Contract carriages is basically the the private bus operators. You must have seen, right? In the cities, there are buses which run on private permit or contract. These are contract carriages, and there are ST buses or state buses. So this was a case where in Karnataka previously that used to operate, and in 1976 Karnataka KSRTC came up and they took away all these contract carriages on themselves. So this is the case. I hope is it clear. Okay, now let us move further and talk about this. So you can see this is another preamble. This is preamble to the Aparajita Woman Child West Bengal criminal laws. Though this did not become a law, but you can see this is a long preamble. Whereas so and so, whereas so and so. So this is a very, very long preamble. This is a constitution. This is a Aparajita task force was constituted in this particular case. So this is a preamble. Now there is a preamble to the Constitution of India as well. So you can see there is a preamble to the Constitution of India. You all know about the preamble. Everybody knows about the preamble. So preamble is giving you the light. So it has been held in many cases that preamble is the part of the Constitution and enjoys the legal force. So preamble of a statute is different than preamble of a constitution. Preamble of a constitution has a higher footing, right? So under the Constitution, preamble is read many a times. So the preamble is the key to understanding the Constitution and interpreting its clauses. In one of the cases, that is Keshavananda Bharti case versus State of Kerala, you may be aware about this case. This was one of the prominent cases which established many judicial principles, separation of judiciary, and basic feature of the Constitution was established in this case. And this is also called fundamental rights case. So in this case, the court said that preamble together with the fundamental rights and directive principles of the state policy are the most important parts of the Indian Constitution, and they constitute the core of the Constitution. That is Keshavananda Bharti versus State of Kerala. And for example, the Supreme Court relied on the preamble in establishing that the constitutional authorities draw their strength directly from the people of India. Like, see, our preamble starts with "we, the people of India," and that is what it says, that the powers are derived from the people of India, clarifying the character of India as a socialist republic, recognizing the possibility of nationalization of private industries in order to secure equity and justice. And this was a period when there were privatization of the privatization was reduced, and there were nationalization of banks, and many things happened at that point in time when this Keshavananda Bharti case was happening. So these references are interpretive, yet their quantity and length indicate a more substantive role in the Indian preamble and the Constitution. This is what Justice Lahoti said in one of his articles, Preamble, the spirit of backbone of the Constitution of India. So I would like to leave you here for a break, because preamble to the Constitution, you can still reflect, read the preamble. If you have any other questions, you can ask me after the break. So we are hereby taking a break of 15 minutes. Let me see the time. It's 7:05, and now we will meet at 7:20. Okay. So see you at 7:20, all of you. Daksh, if you have asked a question, if after the completion of classes I have query to be cleared, how I will contact you. Okay. You can contact me in the LVRC class. I am going to take your LVRC class on 19th. So you read everything by now, and then you can ask me. And if you have any further questions, you can type it here. I will be happy to answer. Or you can come through your regular channel, that is your ICAI must have shared you the details, how to contact the resource persons. Accordingly, you can get in touch with me. Okay. Right. So see you after the break. we left at the preamble of the Constitution, and I was trying to explain you about the preamble, and I was telling you that it is a core of the Constitution. And Aanchal has a specific question as to what is the core of the Constitution, what constitutes core of the Constitution. So when I say core of the Constitution is basically the basic structure. So there are certain things in the Constitution which you cannot, amend, or you cannot take away. This is the soul of the Constitution. And one of the important elements is preamble. So if you see, preamble is there, and preamble reflects upon many things. Like, for example, it is saying justice, not only social, but also economic and political. It is talking about liberty of thought, expression, belief, faith, worship. It is talking about equality. These are all values of our Constitution, and this is the core of the Constitution. Supremacy of none of the wings of the governance, either it is judiciary, executive, or legislature, is the core of the Constitution. Independence of judiciary is the core of the Constitution. So these are the different cores which are very much there, and you have to read it from the preamble. And preamble is a guiding light for interpretation of the Constitution. This is what Justice Lahoti also said in his article. So I hope this is clear. Preamble is clear. Now let us move ahead with another internal aid to construction. And this internal aid to construction is heading. So if you will see in this right side, you can see a section or the chapters from the Companies Act. And you see the first one, that is Chapter 2, Incorporation of Company and Matters Incidental thereto. So this is the heading of the chapter, right? Similarly, if you see Chapter 3, it is talking about prospectus and allotment of securities. These are the headings. So the headings or titles basically prefixed to the section or group of sections can be referred to in construing an act or the legislature. The headings of different portions of a statute can be referred to determine the sense of any doubtful expression in a section ranged under any particular heading. However, they cannot control the plain meaning of the words of the enactment, though they may in some cases be looked at in light of the preamble of there is any ambiguity of the meaning of the sections, so they can help in throwing some light. This is what was held in Official Assignee versus Chuniram in Bombay High Court, 1933. And in Frick India Limited versus Union of India, the Supreme Court said, it is well settled that the headings prefixed to the sections or entries cannot control the plain words of the provision. They cannot also referred for the purpose of construing the provision when the words used in the provision are clear and unambiguous. Nor they can be used for cutting down the plain meaning of the words or provisions. Only in the case of ambiguity or doubt, the heading or subheading may be referred to as an aid in constructing the provision, but even in such a case, it could not be used for cutting down the wide application of clear words used in the provisions. So you can see here that heading has a very limited role in interpretation. They are just there. So if there is an ambiguity in understanding the sections and all, at that point in time, probably you look at the heading, and that too for a very limited purpose, not, it will not change the meanings as such, right? Now, let us move ahead with another important term that is called marginal notes. So in many sections, you would have seen marginal notes. In this left side, if you put a, look at it, marginal notes are basically summaries. So you can see the text in the squares. They are summaries. So marginal notes are summaries, and side notes often found at the side of a section or a group of sections in the Act, and they sum up the effect of that section. However, they are not a part of the enactment, for they were not present when the Act was passed in the Parliament, but these are all inserted after the Act has been so passed. Hence, they are not an aid to construction. So you cannot rely on these marginal notes. Marginal notes are there only for ease of reference. They cannot control the meaning of the section. You have to read the section to understand the exact meaning of the section. I hope this is quite clear that marginal notes are not an internal aid to construction. This is what the note says. Let us look at another important, marginal notes in the Constitution of India. So if you see union and its territory on the left side, name and the territory of the union, that is the marginal note. So in one of the cases, that is CIT versus Umar Bhai, Patanjali Sastris declared marginal notes in an Indian statute as an act of parliament cannot be referred to for the purpose of constituting the statute. And the same view has been taken in many other cases. Many cases show that reference to marginal notes may be permissible in exceptional cases for construing a section in a statute. This is basically in some cases court has dealt with it, like for example, Diwan Singh and Sarabjit Singh. However, marginal notes appended to the articles of the Constitution have been held to be part of the Constitution as passed by the Constituent Assembly and therefore have been used in construing the articles. So this is a divergence between Constitution and normal statutes. So in a Constitution, these marginal notes have been passed by the Constituent Assembly themselves, and hence it is considered to be part of the statute. But if you look at our previous example, these marginal notes are not passed by the legislature. These are subsequently added when the legislature is framed, and that is why it is not considered to be as part of the statute or helping in interpretation. So this is a distinction between marginal notes of a Constitution of India and marginal notes of a statute, normal statute. You can see here in this particular case, on the left side, you see Bharatiya Saksha Adhiniyam. I have taken this from Bharatiya Saksha Adhiniyam. So on the left side, you can see the marginal notes. In civil cases, character to prove conduct imputed irrelevant. In criminal cases, previous good character relevant. Evidence of character or previous sexual experience not relevant in certain cases. All these points are basically with reference to character, and they are marginal notes. Now, this is another interesting dimension of internal aids to construction, and you will see that many of the statute have now started providing explanation or interpretation to the law. Like in this case, the SEBI prohibition of insider trading regulations, there are legislative notes which are provided. So legislative notes are basically explanation of the provisions. So if you see here in this case, section 3, communication or procurement of unpublished price sensitive information. So the section exactly is no insider shall communicate, provide or allow access to any unpublished price sensitive information related to company or securities listed or proposed to be listed to any person, including other insiders, except where such communication is in the furtherance of legitimate purpose, etc. So fine. So this 3.1 is subject to interpretation. But here what legislation is doing, it is providing a note. And it is saying that our intention is specifically crafted. Now you don't have to apply your mind, apply what we are saying, that this provision is intended to cast an obligation on all insiders who are essentially persons in possession of unpublished price sensitive information to handle such information with care and to deal with the information with them when transacting their business strictly on a need to know basis. It is also intended to lead to organizations developing practices based on need to know principles for treatment of information in their possession. So you can see this is the legislative note. Similarly, there is legislative notes. If you see, the committee wishes to highlight a very important recommendation. This is the SEBI has said about the legislative notes. And it has said that how this is going to help in interpretation. And it has said that there are situations where the proposed regulations, have a confusion, and this is going to probably help reduce that confusion. If you refer to para 20, it says penal provision should be precise and should not impose an unfair burden on courts by expecting that ambiguities would be ironed out during legal proceedings. In fact, the committee believes that articulating the legislative intent behind each provisions would be a powerful tool in nudging society towards a greater understanding of the law and a superior degree of compliance, thereby minimizing the scope of litigation. This was Justice K. Sodhi committee, if I am not wrong, who drafted this particular regulations, and this is how they have explained. Now I don't know what is the treatment which court has given to these provisions, but it is interesting phenomenon. I have not seen many legislation with these legislative notes, but in certain one example is this insider trading regulations. So I gave you interesting context in this part. Any other question on this till this point? Any question on internal aids? Yeah. Any question till this point? Yeah, on internal aids to construction. Okay, no questions. So let me proceed. And if you will see, there are sections, definitional sections or interpretation clauses you will find. So definition is very much part of the statute. And object of a definition basically, or the interpretation clause, is to avoid any confusion or frequent repetitions, because every time you cannot describe all the words again and again and again. So you provide a definition section. So if you look at the purpose of the definition clause, it is of two purposes. One, it provides a key to the proper interpretation of the enactment. And second, it shortens the language of the enacting part by avoiding the repetition of the same words contained in the definition part every time the legislature wants to refer to the expressions contained in the definition. So construction of definitions may be understood under the following headings. The first one, restrictive and extensive definitions. So there can be two kinds of definitions. One is restrictive and extensive definitions. Second, there can be ambiguous definitions. Third, definitions subject to a contrary context. So these are the three types of definitions. One is, the first type talks about that definition restricts the meaning of a word. That yes, it means only this much. You recollect, we have talked about the definition means and includes. You remember means and includes. So which one is restrictive out of means and includes? Can you tell? No, I taught you means and includes. We discussed in General Clauses Act. Means is restrictive. Yes. Right. Means is restrictive and extensive is includes. So you can include few more things in this, but when it says specifically means, it is restrictive. Similarly, there may be ambiguous definitions. So if there are definitions which has multiple meanings, it is of no use. Then definitions subject to the contrary context. So many definitions you will find which uses this word subject to the contrary context. That means what? It basically says that normally this is the meaning. But if the context states otherwise, you go ahead with a different meaning. This is what is subject to a contrary context. Then let us further move. And if you see restrictive and extensive definitions, legislature has power to define a word even artificially. And we have seen that in section 8 of IPC, which defines gender. It says the pronoun he and its derivatives are used for any person, whether male or female. And I gave you an example of this under the Bharatiya Nyaya Sanhita. We have now included even transgender into the definition. So 2.9 of the Bharatiya Nyaya Sanhita, gender, the pronoun he and its derivatives are used for any person, whether male, female or transgender. Transgender has been further defined in the Transgender Persons Protection of Right Act 2019. So the definition of a word in the definition may either be restrictive of its ordinary meaning or it may be extensive of the same. So the word where it is defined to mean such as such and such, the definition is prima facie restrictive and exhaustive. we must restrict the meaning of the word to that given in the definition section. If the word is include, as you people have already said, such and such, the definition is prima facie extensive. Here the words defined is not restricted to the meaning assigned to it, but has extensive meaning, which also includes the meaning assigned to it in the definition section. Now, we may also, find words being defined as means and includes, and in this case, the definition would be exhaustive because towards the end, you remember the last antecedent rule. So towards the end, it is includes, and hence here the definition would be exhaustive. In other hand, if the word is defined to apply to and include, the definition is understood as extensive. So this is how you go ahead with, explaining the extensiveness or restrictiveness of a definition clause. You see, there is also a deeming provisions. So in many of the definitions, you will find that definition is worded like it is deemed to include. So section 2M of the Consumer Protection Act contains an inclusive definition of person, and it has been held to include a company, although it is not specifically named therein, right? So this is Karnataka Power Transmission versus Ashok Iron Works. So the definition section may also be worded as it is deemed to include, which again is an inclusive and extensive definition. As such a word are used to bring in by a legal fiction something within the word defined, which according to its ordinary meaning is not included within it. So if you look at the inclusive definition in one of the cases, that is the state of Maharashtra versus Labor Practitioners Association, the inclusive definition of district judge in Article 236A of the Constitution was constituted very widely, including hierarchy of specialized courts like labor court, industrial courts, which are not expressly included in the definition. So if you see the definitions, Article 236 of the Constitution of India, it uses the expression district judge, includes judge of a city civil court, additional district judge, joint district judge, so and so, but it does not include labor courts and industrial courts. But in the case of state of Maharashtra versus Labor Practitioners Association, court said that this definition is inclusive. So as the word include is used, you may include even the labor courts and industrial courts under the definition of district judge. So it is I think you got an example also that how it works. Now there are ambiguous definitions. So there are some definitions which are ambiguous in nature. So generally it is presumed that whenever a legislature is defining something, it will be defining it specifically precise, and they are very careful about their choice of words. However, at times the language used in such sections may require interpretation. Like for example, one of the most interpreted provisions under the Industrial Disputes Act was the meaning of industry. If you see what amounts to industry is a big question. And if you see, there are a lot of cases in which the discussion has happened, courts have gone into it. And one of the prominent cases was Bangalore water supply case, wherein they gave the definition of industry. Now there is I think nine judges bench already sitting over this particular matter, reconsidering the definition of industry, which was laid down in Bangalore water supply, because there is a lot of transformation in the economy now. Be as it may, let us talk about a different definition, which is talking about here is about retrenchment. Okay. So section 2 OBB of the Industrial Disputes Act defines retrenchment, and it says retrenchment means. So you can see here the word is used means. That means whether it will be restrictive or expansive. Restrictive, Isha. Good. So here, if you see, it says the retrenchment means the termination by the employer of the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but does not include. And it has talked about the following situation which are not included in the definition of termination, right? So these are including voluntary retirement, retirement by a workman on reaching age of superannuation, the termination of service of the workman as a result of non-renewal of contract. So this was a question where termination of service of a seasonal worker was done because of the termination of the contract. And it was held that it is not the retrenchment as held in Anil Bapurao Kasare, right? But the termination of employment of a daily wager who is engaged in a project on completion of the project will amount to retrenchment if the worker had not been told when he was employed, that is employment will end on completion of the project. So this is called termination. So this Neelaj Curve Telecom District was manager Karnataka. This is the case in which it was held. That is ambiguous definitions. Another point which I was discussing about is definition subject to contrary context. So when a word has been defined in the interpretation clause, prima facie, on the face of it, we have to see that that definition governs whenever that word is used in the body of the statute. However, if in the body of the statute the word is used in a different context, then you have to see it from that particular perspective as well, right? So in this case, if you look at, this is the case of Vanguard Fire General Insurance Company Limited. Now, if you look at here, in this case, the section 2 began with the words in this act unless there is anything repugnant in the subject to the context. Okay. So it is basically utilizing the term repugnant. Repugnant means otherwise, or you can say repugnant. I will give you the exact meaning. Give me a second. It is basically, repugnant is a situation which is contrary to the context, or you can say which is unpleasant or, objectionable, or is not in line with the provision. This is called repugnant. So here and then come the various definition clause, of which 9 is one. So it is well settled that statutory definitions or abbreviations must be read subject to the qualification variously expressed in the definition clauses which created them. And it may be that even when the definition is exhaustive, in as much as the word defined is said to mean a certain thing, it is possible for the word to have a somewhat different meaning in different sections of the act. And in this particular case, they were discussing about the term insurer. Therefore, in finding out the meaning of the word insurer in various sections of the act, the meaning to be ordinarily given to it that in the definition clause, but it is not inflexible. And there may be sections in the act where the meaning have to be departed from on account of subject or context. So in this case, they have, ordinarily insurer is meaning a person or a body corporate who is actually carrying on the business of insurance. It may be that the certain sections, the word may have a somewhat different meaning. So a perusal of few sections of the act will illustrate that word insurer has been used in some sections to mean not merely a person actually carrying on the business of insurance, but also a person who intends to carry on the business of insurance, but has not actually started it. And also a person who was carrying on the business of insurance, but has ceased to do, right? So you can see it is not only the present insurance, but it is the people who used to do the insurance business and the people who are planning to do the insurance business. They are also included in the definition of insurer. So this is an interesting case. And I think a bit of a legal verbose. I don't want to, impose you with too much of legality, but I just wanted to, give you a context that a definition clause in certain situations may have different meanings also in the text, but in a normal situation, and this is, I am giving you an example of definition subject to the contrary context. So if you see the definition, generally it will appear throughout the statute as is the same meaning, but in certain situations you may have different context as well. So if The law, if the section specifically is mentioning about a definition and giving special qualification to that definition in that section, you have to read the section. I told you a rule long back that how do you interpret? You will first see the section, though you have to read the statute as a whole, but if the section itself is making sense, you don't have to go anywhere else. But if the section is not making sense, you go to the definition clause, then you see the statute as a whole, and then you make an interpretation. Well, there are also illustrations. So you will find in a statute, you will find illustrations as well. Like for example, here I am giving you an example from Bharatiya Saksha Adhiniyam. So you can see here, there is a section on closely connected facts. Now here, there are number of illustrations, A, B, C, D. These are all illustrations. So illustrations are basically appended to a section, attached to a section, and they form part of the statute. Although forming no part of the section are of relevance because they explain you the circumstances and situations. Okay, so you cannot reject them as such. However, they will not have much effect of modifying the language of the section. They cannot either curtail or expand the ambit of the section, which alone forms the enactment. So you have to be careful that while illustrations can be helpful in understanding the meaning of the section, at the same time, illustrations cannot take away the meaning or alter the meaning of the section. Like in this case, if you see, it is talking about closely connected facts. And let us look at one of the illustrations. Illustration D says, the question is whether certain goods ordered from B were delivered to A. Here it is evidence law. So the goods were delivered to several intermediate persons successively. Each delivery is a relevant fact. So it is saying that each of the, if there are closely connected facts in evidence, you have to establish a case. You have to look at the evidence stepwise, right? So the question is whether certain goods ordered from B were delivered to A. The goods were delivered to several intermediate persons successively. Each delivery is a relevant fact, right? Now let us move further and talk about the Indian Contract Act. So if we look at Indian Contract Act, we have communications when complete. So section 4 talks about communications when complete, and you can see here there are illustrations. So it is giving you the illustrations. It gives you the example as to how the communication will get completed. So these are some of the examples of illustrations. This is another example of illustration in Jama Masjid versus, Kodi Maniandra Devaya, 1962 Supreme Court. The illustration was appended to Transfer of Property Act, right? And this is the illustration. A Hindu who has separated from his father B sells to C 3 fields, A, X, Y, Z, and representing that A is authorized to transfer the same. Of these fields, Z does not belong to A. It has been retained by B on the partition, but on B's dying, A as here obtains Z. C not having rescinded the contract of sale may require A to deliver Z to him. Now you see, illustration itself is too much confusing, right? First you have to understand what is illustration, and then you can go ahead. So this is basically a law of succession. It is a bit confusing law. But here you can see in this case, the court has said that you should not readily assume that all illustrations to a section is repugnant and it should be rejected. You have to consider these illustrations in positive sense and try to make meaning out of that particular section. So in this case, when A sold the field to Z to C, he had only a spes successionis. This is a maxim of succession law, and he giving subsequently inherited it, become entitled to it. This would appear to conclude a question against the appellant. So this is how the illustration gets interpreted in courts of law. I will not go into much of these particular detail because I have to teach you succession law then to understand this case. But I'm just trying to put the point before you that illustrations are read by courts in interpreting the provisions of law. Now, let us talk about another, in this particular case itself, let us move ahead. This is a case appended means attached, basically, attached or below that particular section. So in this case, the court referred to, Muhammad Shaul Afrin case, and the court said that it is the duty of the court of law to accept if that can be done. The illustrations given as being both of relevance and value in the construction of the text. The illustrations should in no case be rejected because they do not square with ideas possibly derived from an other system of jurisprudence. As to the law with which they are the sections deal, and it would require a very special case to warrant their rejection on the ground of their assumed repugnancy to the sections themselves. It would be the last resort of construction to make any such assumption. So what it is trying to say? It is trying to say that you make sense out of the illustration, but if at all you find that it is making no sense or it is repugnant, then you can ignore it. So if the language of the section clearly excludes from its purview certain matters, it would not be legitimate to use illustration to include those matters into the section, right? So this is Justice Iyer T.L. Venkatramana in case of Vickers versus Evans. He relied upon this particular case in that. Then comes proviso. Proviso is very, very important thing which you find in the statutes. Like, for example, in this statute on the right side, Bharatiya Saksha Adhiniyam, let us locate the proviso. This is the proviso, right? So first section is that, and then it creates an exception. It says, provided that opinions of expert expressed in so and so, right? This is the one proviso. Then there is a second proviso. You can see, provided further that if oral evidence refers to. So there may be many provisos to a section. These are all provisos. So when I say proviso, it is a normal function of a proviso is to accept something out of the enactment or to qualify something stated in the enactment which would be within its purview if the proviso were not there, right? So this is about the nature of proviso. Usually, a proviso is embedded in the main body of the section and becomes an integral part of it. Provisos that are so included begin with the words provided that. I have shown you the examples. The effect of the proviso is to qualify the preceding enactment, which is expressed in terms which are too general. As a general rule, a proviso is added to an enactment to qualify or create an exception to what it is there in the enactment. Ordinarily, a proviso is not interpreted as stating a general rule. So proviso is not a general rule. Proviso is an exception. Now, there are two things. One is, exception clauses, and then there are proviso, and then there are saving clauses. So there's a distinction between these three. So exception clauses are intended to restrain the enacting clause to a particular cases, right? So exception clause creates a restriction that, okay, fine, it will apply only to X class of people. Saving clause is used to preserve from destruction the certain rights, remedies, privileges. You would recall the saving clause when we saw in General Clauses Act the repeal of laws. So there was a saving clause, right? In Competition Act, you have seen the saving clause. So it saves the repealed action taken under the repealed enactment. Now, in Ram Narayan Sons versus Assistant Commissioner, the court said that it is cardinal rule of interpretation that a proviso or exception to a particular provision of a statute only embraces the field which is covered by the main provision. So proviso cannot go beyond the main provision. Let me give you the example here. So if you see, these are the two provisions, provided that and provided further. Now these provisos cannot go beyond section 55, right? So you have to see that the field of operation of this proviso is within oral evidence to be direct. It cannot go to proof of facts of oral evidence. Am I clear? So you have to see that this proviso is with reference to that section, and hence it should apply to that section itself, not beyond that. This is what court said in Ram Narayan Sons versus Assistant Commissioner. So if you have to quietly distinguish between these three. Exception is intended to restrain enacting clause to particular cases. Proviso is used to remove special cases from general enactment and provide for them specially. And saving clause is used to preserve from destruction certain rights, remedies, or privileges already existing. So this is how you go ahead with proviso, exception, and saving clause. This is further distinction. If you have a look at them, you will be able to understand it. I want you people to read this yourself and ask me any question if you have. Is it making sense to you? Please read it. And then, Daksh, what is legitimate? Legitimate means legal. You don't have to remember all these case laws, but if you remember few, it will be good. If it is a long answer, then you have to write. If it is a short answer, then there is no requirement, I believe. Kindly see the format of your questions and the answers. I will also share a set of questions which is there in a document on your learning management system. So kindly read this and try to find a meaning out of Okay, so you have got the difference between these three. If you concentrate on example, you will be in a better position to understand that. So if you see section 6 of the Transfer Property Act, they are talking about proviso. Okay, they're saying provided that nothing in this section shall affect the transfer of property by an unmarried Hindu governed by this Hindu Succession Act. So Transfer of Property Act talks about transfer of property in all cases except the unmarried Hindu governed by Hindu Act, right? So this is what it is trying to say. What is the general rule? General rule under the Property Act. And what is the exception? Exception under the Hindu law. Proviso, but through the proviso. And in exception, it excludes a case entirely from the general rule. Like, for example, if you talk about section 300 of the IPC, which defined murder, except in the cases hereinafter, accepted culpable homicide is murder. So there are exceptions like grave and sudden provocation. These are exceptions from the murder. They are completely excluded as they cannot come under the definition of the murder. Saving clause, it ensures legal continuity. Like, for example, section 6 of the General Clauses Act, as I told you, where any act or anything is repealed, then if a thing is done in that act, if a right has accrued, if a liability is there, that will not extinguish or the right will not go away, right? So this is about the proviso, exception, and saving clause. Now, another internal aid to construction is explanation. So you have seen in this. So can you tell me what is the red one, the red square in this left side document? What is that called? Red side. It is not short title. Daksh, it is not short title. Yeah, what is that? Anyone else? It's heading. Very good, Narsimha. It's heading. And can you tell me what is this? See, another red box which I just opened. Okay, very good. These are marginal notes. Good, Vedant. Okay. Now, if you see in this heading of documentary evidence, section 57 talks about primary evidence, right? So if you have a look at it, it has given explanation. So it is trying to explain. So explanation is at times appended to a section to explain the meaning of certain words or phrases used in the section or of the purport of that particular section. So an explanation may be added to include something within the section or to exclude something from it, right? So here, if you see explanation 1, it says where a document is executed in several parts, each part is evidence of the document. So like this explanation are given under Bharatiya Saksha Adhiniyam. If you see in one of the cases, that is Sundaram Pillai versus Pattabi Raman, Fazal Ali Justice gathered the following objects of an explanation. And this is part of your course material. So explain the meaning and intendment of the act itself. Clarify any obscurity and vagueness. Obscurity means something which is hidden. Obscurity and vagueness in the main enactment to make it consistent with the object, and provide an additional support to the object of the act to make it meaningful, and fill the gap which is relevant for the purpose of the explanation to suppress the mischief and advance the object of the act, and cannot take away the statutory right. This is the objective of the explanation. Then in the statutes, you will also find schedules. Toward the end of the sections, you will find schedules. Like, for example, we are having schedules to Companies Act, Schedule 1, and there are different tables in the Schedule 1, which talks about Memorandum of Association and, Memorandum of Association of different types of companies. So the schedule form part of the Act, therefore they must be read together with the Act for all purposes of construction. However, expressions in schedule cannot control or prevail over the expression in the enactment. So if there appears to be any inconsistency between the schedule and the section will always prevail. So you can see here in this Schedule 1, they are referring to section 4 and 5. So if you find something in the clauses of the schedule which is inconsistent with section 4 and 5, section 4 and 5 will have a precedence over these schedule provisions. I hope this is clear to you. Then very important thing is punctuations, but this is in an additional material. This is not part of your syllabus. I just wanted to point out to you that many a times punctuation creates a lot of issues. So punctuation becomes an important interpretation point, because punctuation like comma, semicolon, colon, dashes, they help identify the structure of the law. And many a times a comma may create issues, right? So if the punctuation is not right, then you need to look at that very, very clearly. So punctuation, though in India, punctuation has been taken into consideration in many cases, but not detailed many cases. I think there are very old cases in which punctuations have been considered as an interpretation tool. But I remember one of the cases in which, because of a comma, there was a contract which was lost because of a comma interpretation. So comma makes sense and punctuations make sense, in particularly when we are interpreting the deeds and contracts. Now, we have already seen this particular point before, that is, statute must be read as a whole in its context. So it is elementary principle that construction of a statute has to be done by reading everything together. So you cannot read them separately. So if one section of an act requires notice should be given, then verbal notice would generally be sufficient. But if another section provides that notice should be served on the person or left with him, or in a particular manner or place, then it would not be sufficient to give a verbal notice. So if there is a methodology provided for giving a notice, you need to follow that methodology. Particularly, I will tell you under the Companies Act for doing meetings, there are detailed notes by Company Secretaries Institute, which you have to follow for conducting the meetings. So if that specificity is there, you cannot just give a oral notice and then get away with it. Okay. So you have to be very careful when you are talking about statute must be read as a whole in its context. Now we move on to the second leg or another leg of today's presentation that talks about external aids to interpretation or construction. So when I say external aids to construction, I have given you the explanation before also. External aids basically means other than the statute. So if I have a law and I go beyond that particular law, it will be called as external aid to construction. And if you look at the different types of external aids, they are historical setting. Like many a times you go back to the history to find out what was the law before, why this law came up, what was the mischief. This is called going back to the historical setting. Then you go back to the previous statutes or consolidating laws. Then you also see the usage, that how the law has been used since so many years and how it has performed. Then you also see the later acts, analogous acts, pari-material law. Then sometimes you also look at dictionary and you also look at the foreign decisions that many a times court uses the foreign decisions, and I will explain you one by one. Let us take the first one. This talks about historical settings. So history has a huge role to play in legal interpretations. So whenever there will be a question of interpretation, you would go back to history and try to find out what has happened then, what was the report about. You take any cases, landmark cases. The judges would go back to history, including the case laws and precedents, and try to find out what was happened before. So history is an external circumstance and, which led to the enactment in question. And you have to see many a times for interpretation, they go back to that historical facts. Like, for example, if you have followed the Ram Janmabhoomi case, everybody went to the history. The courts went to the history. What has happened when the idol was there, when it was not there, how things went ahead. Then you look at any other cases, they went back to history. Like, for example, if you talk about Aruna Schonbach case, or you talk about Kuttuswamy's case, all these cases, courts have gone back to history to see the origin of privacy law in Kuttuswamy, like that. Now, if you, history plays a very important role, and I think in Indian courts have gone many a times back to the history to find out the legislature's intent in coming up with that legislation. Then there are consolidating statutes and previous laws. So a consolidating statute is basically a statute which brings together the several earlier statutes on the same subject into a one comprehensive legislative document. And when you are interpreting that consolidating statute, you are basically, looking at the structure and language used in that consolidating statute. You also look at the earlier enactments. If there are any ambiguities you want to clarify or interpret the technical words and phrases. You also determine whether the consolidating statute seeks only to restate the existing law or they are introducing something new. Like, for example, if you see our, Bharatiya Nyaya Sanhita, it is a consolidating statute. But if you have to go back to IPC, if you will see, it has, consolidated and brought things together, but it has also introduced some new concepts into the Bharatiya Nyaya Sanhita, like, for example, community punishment. So like that. So let me take you example of Companies Act. So Companies Act 2013 is a consolidated law and it replaced several earlier laws, including Companies Act 1956. And prior to that, there were a number of other legislation. And Section 212 of the Companies Act regarding Serious Fraud Investigating Office, SFIO, was brought new. And that incorporates elements previously scattered across the older laws. And they are bringing it into a consolidated framework. That is what you saw in this particular law. Now, if you see the previous laws, you go back to judicial interpretation of previous sections and find out what is the ambiguity and try to make sense out of that. Like, for example, General Clauses Act 1897 is frequently referred to for interpreting terms in statutes that succeeded earlier law. For instance, if a statute does not explicitly define a term, courts look at how the term was defined and applied in previous legislation to ascertain the meaning. One example could be the Bengal Immunity versus State of Bihar, 1955, where Supreme Court went to the pre-constitutional tax laws and earlier statutes to find out the meaning of the term sale of goods under the Constitution. So like this, the consolidating statutes and previous laws are utilized by the courts many a times to interpret the provisions of the laws, but these are all external aid to construction. Then there is something which relates to usage. So what is usage? Usage is sometimes taken into consideration, and usage is basically the act which is done again and again over a long period, that is called usage. And it may be emphasized that when a legislative measure of doubtful meaning has for several years received an interpretation which has generally been acted upon by public, the court should be unwilling to change that interpretation. So if something has been going on since long and it is by usage established, generally you will not like to change that particular usage unless it is contrary to public policy. Like, for example, Sati Pratha, that was a usage, but it was removed by law. Similarly, Triple Talaq, that was a usage, but that was again removed by law. So usage against public interest or changed policies are not permitted, but generally usage would be considered. Let us take an example. The Income Tax of India Act includes several terms that may be subject to interpretation, such as income or capital asset. So in one of the cases, CIT versus Taj Mahal Hotel, Supreme Court of India dealt with the interpretation of the term plant. So there was a term called plant under the Income Tax Act. Now, generally, when you talk about plant, it is referring to furniture, fittings in a it is referring basically to machineries, plant when we are talking about furnace and all those things. But with reference to a hotel, the question came before the court that can we consider the furniture in a hotel, its fixture like bed and all those particular things as a plant or not? Because it is an industry. And in that industry, plant means what? It will be kitchen equipment and all those particular things, whether that will be considered as plant or not. So in this case, the court relied on the usage in the hospitality industry. And they said, where furniture and fittings were recognized as integral to the operation of a hotel, based on this understanding, the court held that such items fell within the meaning of the plant, which could qualify for depreciation under the Act. This shows how court uses established practices and industry-specific meanings to resolve statutory ambiguities. Quite an interesting case, right? So whenever you now next go to a hotel and find a furniture, you would know that under Income Tax Act, this is a plant. That's good. Now let us move further and talk about earlier acts, later acts and analogous acts. But before I move further, any questions till this point? Any one of you? Any questions or any clarifications till this point? Okay. So earlier and later acts and analogous acts, when I talk about that, so the general principles is that the different statutes in pari materia, that is in analogous case, though made at different times or even expired, are not referring to each other. They shall be taken into construction together as one system and as explanatory to each other, right? Now, if two acts are to be read together, then every part of each act has to be construed as if contained in one composite act. But if there is some clear discrepancy, then discrepancy may render it necessary to hold the later act had modified the earlier one. So whenever there are more one or two acts, you have a specific way of interpreting them. So suppose the earlier bylaw limited the appointment of the chairman of an organization to the person possessed of certain qualification, and later bylaw authorizes the election of any person to be the chairman of the organization. In such a case, the later bylaw would be so construed as to harmonize and not to conflict with the earlier bylaw. So you have to see that there is a harmonious construction which is brought further. So if there are series of laws and you want to interpret a situation, you will try to harmonize it rather than, deprecating the earlier law and taking care of the only new law like that. Earlier act explained by the later act. Not only may the later act be construed in light of the earlier act, but the later act sometimes furnishes a legislative interpretation of earlier one if it is a pari materia. Pari materia, I have explained you the concept before. Where the earlier statute contains a negative provision, but the later only merely omits that negative provision, this cannot itself have the result of substantive affirmation. So whenever you have to refer to the repealed act, you have to see that whether the repeal is taking away the operative force of the previous law, or it leaves something out of that. So if it leaves something out of that, then you have to see, like, for example, it always uses the word right, that the rights liability accrued in the previous law will continue. So the new law cannot just take away that because the law is protecting it. So this is a background of that. Now, many a times court also refer to dictionaries. I don't know how many of you refer to dictionaries, but there are two kinds of dictionaries as far as law is concerned. One is Oxford Dictionary, which is a general dictionary of English language. And there is dictionary, which is legal dictionary. It is called Black's Law Dictionary. So if you have to find out a meaning of a word, where do you look at the first? Where you will look at first, where you have to see the meaning of a word. Say, for example, you want to understand the meaning of a word. Where do you look first? Glossary? No. Daksh. Now see, I have taught you, so fourth class is now going on General Clauses Act and interpretation. So give me right answer. Where do you find the meaning of a word? If you have to go, where you will go? Yeah, you will go to the definition clause, right? So if you have to find a meaning of a word in a statute for interpretation, you go to the definition clause of that section. If you don't find the meaning of a word in the definition clause, where do you go? Yes, my question is very specific. If you don't find a meaning of a word in the definition clause, where do you go? General Clauses Act, yes, but can you go to something else before that? Before going to General Clauses Act? And this I have taught. Yeah. Dictionary comes very later. We are still finding the meaning. Preamble, okay, fine. You go to the preamble, you try to understand that, you see all internal aids to construction. But outside the statute, you can go to the pari materia statutes, right? Like, for example, if you are referring to Competition Act, if you don't find a meaning in the Competition Act, where you can go? You can go to the Companies Act, right? If you don't find the meaning in the Companies Act, then you go to the General Clauses Act. Or also you can look at the pari materia statutes, like, for example, IBC, or similar kind of statutes, you will see pari materia statutes. Now, if you don't find meaning in any of the places here, you refer to the dictionary. And these dictionaries help you understand the meaning, and you try to, make sense of the word which is confusing. And I can tell you that courts have used dictionaries at multiple times in interpreting the words. Now coming to the use of foreign decisions. So Indian courts have been using the foreign decisions in many of the cases, and foreign decisions are used quite liberally in India.
Recording stopped. Recording in progress.
Has been, quite used liberally in India. Like, for example, you have Keshavananda Bharati case in state of Kerala, 1973, wherein the Supreme Court referred to basic structure doctrine. In Vishaka versus state of Rajasthan, CEDAW was referred to. This is the Convention on Elimination of All Forms of Discrimination Against Women. And then, Vishaka versus state of Rajasthan, CEDAW was referred. Likewise, many other cases you will find that courts has used the foreign decision. So in India, they look at it, but they have persuasive value, and courts have tried to interpret the provisions in the Indian context, but they have taken help of some foreign decisions as well. Like, for example, if you see Puttaswamy's judgment, the court has referred to multiple articles by foreign authors in that particular case. Justice D.Y. Chandrachud referred to that, gave that particular decision one of the opinions. Then we are moving to the last section of our class today, and that is rules of interpretation of construction of deeds and documents. So the first and foremost point with reference to deeds and document is that you have to look at the documents from a reasonable man perspective. Now, who is a reasonable man? Reasonable man is a person who is of average understanding. We are not looking at super genius people. We are talking about a common man who must understand this. Okay, so that is the standard. So you look at from that particular perspective. And the principle of construction is that you do not, is not much different, as I told you, from the statutes. You have to read the statute the document as a whole to understand the meaning of the several clauses and the words. And you have to give the normal meaning to the words which are used in the sentences. And you have to make an endeavor to make the agreement workable and understand the words of the document. So the golden rule of construction is to ascertain the intention of the parties. That is very important in case of deeds, construction of agreement. You have to find out what parties actually meant, what was the natural sense of the agreement. So to ascertain this intention, the court has to consider the relevant portion of the document as a whole, and also to take into account the circumstances under which the words were used. Very often, the status and the training of the parties using the words have to be taken into consideration. Like, for example, if two contractors are engineers, that agreement will be dealt with differently. And if an agreement is between an uneducated person and an educated one, that will be dealt with differently, right? So this is how the interpretation of deeds and conveyances happen. Now, it has to be also borne in mind that many words are used more than one sense, and you have to find out the sense of that particular word as it is used in the conveyance or the agreement or the deed, right? Now, it is inexpedient to construe the terms of one deed by reference to terms of another, and it is an elementary rule of construction that the same word cannot have two meanings. And these are some of the cases where a deed of construction deed interpretation has been talked about. So if there is a conflict between two or more clauses, then an effort must be made to harmoniously construe that particular law and make a sense out of that agreement. So if there is one part of the document, if it is conflict with another part, then there is always an attempt made to make the document workable, and the part which is not workable is left aside and remaining parts are made workable unless the result is catastrophic. So these are some of the references which I have utilized in making the lectures. And if you are interested more on interpretation, you can read Justice G.P. Singh. This is a good book which I referred as in my student days, and it gives you a number of case laws on different points. As I told you before, that it is a 4 credit course in LLB, and there is a detailed teaching which happens on each of these case laws, and thrashing happens, and students keep discussing that. Now, I think as CAs, you are not required to do it, but as CA, you must also be conscious about what these rules are, interpretations are, so that when you are talking to some lawyers, you are also, can be part of that discussion. So at the time of interpreting a statute, what will be the effect of usage and customs? So this is the questions. These are some of the questions which I wanted to discuss with you, but I think we are already at 8:27, but we will talk about this briefly. So if you see here, at the time of interpreting statutes, what would be the effect of usage? This is the question which has been asked. And I think one of you asked me that what kind of a question is coming. So you can see this is the questions which you will find out, which is coming. Somebody asked me, what is your PhD into? I did my PhD in corporate criminal liability. So that is my PhD. So if you see effect of usage, this is how you reply. So usage or practice developed under the statute is indicative of the meaning recognized to its words of contemporary opinion. So this is what is the response. I will share this slide with you. Another question is this. Can you read this and explain? This I have already discussed many times, so you can easily answer it. This is directory and this. So you can say it is shall. Here may is read to be read as shall. When can the preamble be used as an aid to interpretation of statutes? Preamble can be used in 2 situations. One, where there is any ambiguity in the words of an enactment, the assistance of the preamble may be taken. Situation 2, where the words of an enactment appear to be too general in scope for application, then courts may resort to the preamble to determine the scope or limitation for which the words are meant. This is another question. Explain the meaning of without prejudice as a harmonious aid to interpretation of statutes. Yes. Can you answer this question? Without prejudice. What do you mean by without prejudice? Yeah. Any one of you can answer without prejudice. Okay. Resolution to conflict without being biased, not exactly. Without prejudice, we say that without, sacrificing my rights or without sacrificing my right to object, I am listening to you. This is called without prejudice. Without prejudice. Okay. So when certain particular provision follow general provisions, and when it is stated that particular provisions are without prejudice to those general provisions, the particular provision would not restrict or limit the operation of generality of the proceedings, right? This is called without prejudice. This implies that while registering and deciding the name of the company, provisions 4.2 shall be operated. So friends, this is what was from my side, and I will be happy to answer any specific questions you people have. Okay. Yeah. Questions? Prima facie, Daksh is basically saying that on the face of it. So many things are apparent or clear on the face of it. So prima facie is a normal legal term which is utilized many a times. Now, I think, unfortunately, these words have become our daily language. So we always say prima facie, it appears to be good. That means on the face of it, without further detailed inquiry, it is appearing good, like that. Case study won't come, Vedant. It is mostly the descriptive answers which comes. So I think that is how you have to prepare it. So I gave you a tip in my last class that you, on all these particular topics, prepare your own notes so that you have clarity. So whenever a question comes on to a issue, you are able to write it. Okay. Okay, then if you have any questions, you can ask me, or then otherwise we can call it a day. Parimateria. Okay, Sridhar, parimateria means similarly situated, right? So this is called parimateria. Like, for example, we can say that legislation, similar economic legislations are parimateria, like Competition Act and Companies Act, they may be considered as parimateria because they are dealing, both of them are dealing with companies and their actions. Yeah. I don't have an answer for this, Narasimhan, why so many Latin words appear, because we inherited our laws from English system and it all started in Latin. That is why there are a number of words which are in Latin. But now Indian government and the judiciary is working towards reducing them. However, in our ancient texts, this is used, and it is used in laws, hence it is used. External aids, Anil, cannot clash with internal one at any point in time. You go to external aid only when internal aids are not sufficient. Otherwise, there is no need to go to external aids. So there is no clash between them. Okay. Any other question? Any one of you? Okay, so thank you for your time. I will be also taking your LVRC session on these four topics which I have taught, probably on 19th. And I think tomorrow we are going to have an LVRC on prospectus and allocation of securities in the morning. So looking forward to see you all. Thank you for your patient hearing. And if you have any questions, you can jot it down and you can ask me during the LVRC session. Thank you again. Have a good night. Bye-bye.